Yes, Mr.
afternoon. Good afternoon. We had one bit of homework, which was to attempt to agree what proportion of the interest would be taken out of charge if my learned friend was right on ground 2 but not ground 1. That's to say, what proportion of the interest would be not yearly interest if one just looked at whether the loans taken individually were loans of less than a year. The figure's about 40%.
40%.
We did that by reference to the capital of the loans. It's not exact because the shorter loans will bear less interest than the longer loans, but for illustrative purposes, we're happy to say 40%.
So ground 2 is really about 60% of what?
No, ground 2 is about 40%. It's that way round.
Is it the other way around? Is it?
So around 40% of the loans were, in fact, lasted less than a year. Is that the
40% by value?
Yes.
Were loans that were on their face less than a year.
It's not 40% by value of interest or tax.
No, we've only got access to the capital,
Okay.
and obviously that's not precise
Right.
because the longer loans have more interest. But
Yes, I'm sorry, I was confusing myself. So in essence, and for reasons perfectly understand, the appellant is not pursuing 60% of the amount, but is focusing in the ground 2 on 40% of the amounts involved.
Yes, but obviously ground 1 applies to
The
everything.
ground 1 is 100%.
Well, sorry, it's not actually. Sorry,
No,
but
I
it's
didn't think that was the case.
sorry.
I wanted to
It's
understand.
ground 1 is everything that was paid to Hume.
Yes, but how much was that? Do we know?
Oh, that.
I thought it wasn't all of them.
No, it's not all of them.
And it's only
Not all the
some,
original ones,
and it's only some years as well.
and it's only the later years. We'll get that figure.
Well, I mean, all of this is sort of nice to know information because it doesn't affect the points of principle, but it's just always nice to know.
Well, you need to, I think we want the court to have a feel for
Yes.
what sort of. I mean, they're large-ish numbers, not the largest that this court will have seen, but they're large-ish numbers. The ground 1 is a larger number than ground 2, but we'll come up with a better figure whilst I'm speaking. The other preliminary matter I wanted to say, I'm appearing with Ellen Junior Calypso Large. For the avoidance of doubt, we would have considered speaking part for her in line with last term's exhortation from the various heads of division and so on and so forth, particularly given her contribution to the skeleton, which I'd like to record. But she's appearing as a junior and not a C panellist, and that means that under the GLS policy, the revenue isn't allowed to instruct her to undertake advocacy.
Yes.
I'm flagging that partly because I do want her contribution to be noted, and partly because I think it's right that the court knows that the revenue has that difficulty, and it's not dodging its responsibility to consider the point. Its hands are tied.
Right.
The other bit of homework, which I suppose we were given early on, was about the purpose of withholding. We may have taken it.
Well, not the purpose of withholding,
Or
the purpose
carve-out.
of these carve-outs.
Yeah, well, I had taken them really to be one and the same,
Okay.
and to be as summarised in paragraph 8 of the Upper Tribunal decision, which is tab 5 of the core bundle, page 58. Again, we may have taken this too short, and that is piggybacking. Well, that's based on LOMAS, which is in the bundle if we need the whole thing. But
Sorry, para 8 of
para 8 of the Upper Tribunal, which is on page 58 of the bundle, page 3 of the decision. I mean, that's obviously a short statement.
But my question was much more specific than that.
Well, the reason I say I hope that was sufficient is that it is implicit in that you don't need the mechanism if you are going to be collecting the tax from a UK resident. But it's not specifically about, I accept, it's not specifically about the UK resident company point or the branch or agency point.
Yes.
But that's, we say that at least the thrust of it Now, there are only two issues for this court: whether Humet was beneficially entitled to certain interest payments, as that phrase is used in the context of these particular provisions, and I will come back to that, and whether the interest payments, including but not limited to those made to Humet, were yearly. And again, I will be saying that that question is quite easily answered in light of the Supreme Court's decision in Lehman. I don't think I need to go through the facts in detail. They're summarised in our skeleton. I do need to emphasise, well, I don't think this is common ground now. These were tax avoidance arrangements. They're arrangements put in place to procure tax advantage. That tax advantage was that the payer would obtain a tax deduction, but the recipient would not be liable to UK tax. That doesn't mean, I'm not saying for a second, that that in itself means that the revenue wins or that the taxpayer loses, but we say it does provide important context for certain aspects of the arrangements.
Why would Humet not be liable for UK tax?
Humet would not be liable for, well, it didn't pay UK tax.
Well, that's because you didn't ask it.
Well, we didn't know about it.
You didn't know.
So the revenue wasn't in a position to ask it for tax. It returned it. It didn't pay. It didn't offer to pay tax. I accept that if Humet had been a UK resident taxpayer earning,
It was a UK resident taxpayer.
okay, as a UK resident taxpayer, because of its incorporation, not because of its place of management and control, it should have been liable for tax on its profits. Presumably, its answer is that it didn't make any significant profits on these.
Was it entitled to set the capital cost of buying the assignment against the revenue stream it got?
We don't know anything about the basis on which Humet appeared. Well, what we know from its accounts is that it did that for accounting purposes.
That doesn't answer a tax question, does it?
No. Well, if it's trading, if that is part of a relevant trade, it would be entitled to calculate tax on that basis.
Yes, but if it was purely a tax avoidance device, would that be trading? If the entire arrangements are artificial?
No, it probably wouldn't be, but we don't know anything about it.
Nobody seems to know anything about it.
No, they don't, because it emerged after the inquiry window had closed for the revenue, and it disappeared again by being dissolved in 2018. We know a few things about it, which are recorded in the judgment, in the decision of the Fist Tier Tribunal, and we would say that this court is obviously concerned with those findings of fact. There's been no challenge to the underlying findings of fact by the FTT, and which were effectively adopted by the Upper Tribunal, as one would expect. What we've got is a company that's where things are inserted, where Humet is inserted purely for tax avoidance reasons in the hope of procuring freedom from the withholding obligation. That's
Can you help me at least as to following my lord's question, that the repayments of interest on the loans depart from the appellants, and they depart gross without tax having been withheld.
yes.
They then move through one or two stages and arrive at Humet.
Well, they're paid to Humet gross.
In a gross.
Yeah, there's no
State.
withholding applied to the payment.
So what is the? I mean, forget who's responsible for paying it, but as it arrives in the hands of another company, what is the nature of the tax debt in regard to that sum as it arrives? What tax would be due? Is it the same tax as would have been due?
Well, I mean, the revenue's position is that withholding should have been applied.
Yes, I understand that, but I'm just trying to work out if the argument is, well, you don't have to look to us for the tax because you get it in this UK company. Would it be the same form of taxation?
Well, if Humet had been paid
Yeah.
The amount beneficially, if
Yes.
it had been beneficially entitled to the interest payment,
would they have had the identical tax obligation?
Would they have had a withholding obligation on the payment on,
No, I don't think that's the question.
or would they have had their own tax liabilities? Is that the
Yes,
question?
exactly. I mean, I
Well-
you know that you know, just looking at it dispassionately, there is tax to be paid
Well,
by somebody, and I'm just wondering whether it's the same tax. That it would simply be that the obligation that previously existed in the hands of the appellants then would devolve to
no,
human.
because the appellant's obligation was a withholding obligation, and Humet's obligation would have been to pay tax on its.
A paying obligation.
Yes.
Sorry, I know my lady wants to.
Can we take it away from Humet and just look at a situation of interest being paid to a UK resident company? And let's say it's before these rules were introduced to have a carve out which gave an exception from withholding tax. The treatment would have been, wouldn't it, that interest would have had to be withheld unless it was from a bank, paid to a bank. Tax would have to be withheld. Technically that's income tax, but the recipient has to bring that into account for tax purposes. Now technically that's corporation tax, but it would offset the income tax that it's been withheld pound for pound.
If it's a payment to a company.
Right, so it would be the same amount of tax, except it would have
Well,
become
more because the corporation tax rate was higher.
Well,
but
if if the recipient is the corporation taxpayer,
Yeah.
when you may recall that there was a time when bank interest was paid net, and you claimed a credit on your personal tax return. But it's the same sort of arrangements, isn't it?
Yes.
That the payer withholds tax, and the recipient withholds and accounts for tax, albeit in respect of someone else's income. And the person whose income it is returns that and claims credit for the withheld tax. So that would have been how it would have worked without the exceptions, with the wrinkle.
But so when one was looking at the commercial reality of this, I mean, I appreciate we're working within the four corners of the findings of the FTT, but just stepping back from this, you said a moment ago, well, we could have gone to Humet or whoever it was if we'd known about them.
Well, what I'm saying is we don't know enough about Humet to say exactly how Humet might have been taxed.
No, but let's suppose let's suppose somebody in the position of the appellants wanted to, for some reason, wanted to be candid about what was happening, and they said, "Well, we have a relationship with you, the taxman. We want a good relationship. We're not withholding. We're going to be doing this, and it's going to end up with this UK company, and you can go knock on their door and collect."
If Humet were a factoring company, for example, and it was paying 80 to get a debt of 100 and paying real money on its term, I don't think there'd be any particular difficulty with that.
No, but I mean, this may not be a relevant consideration or a permissible one for us, but the fact that the money is not withheld, it goes off into, as far as you're concerned, the long grass, and you don't know that it's gone, and you don't know that it's arrived.
Well, the revenue's position is that because Humet is not beneficially entitled to the interest when it's paid, the withholding obligation applies, and it would also follow from that Humet is not going to be taxable on that. It's just passing through Humet.
But I mean, we've just looked at, you've taken us to Lomas, and the purpose of the withholding carve out is to give you assurance that the tax is going to be collected.
Yes.
And I'm just wondering what assurance arises in a sense where you're not even aware of where the money has travelled.
The question is whether the payer reasonably believes the recipient to be a UK resident company beneficially entitled to the income as it arises.
Yes.
And if that condition is met, then the withholding doesn't operate. I mean, the assurance is, in a sense, the good faith of the people operating the payer operating the system. and the expectation that if you're making a payment to a UK resident, that UK resident will be compliant. And if the UK resident isn't compliant, in the case of a company with corporation tax, in the case of a
But I appreciate these are very naive questions, but if the whole purpose is that tax shouldn't be paid at all, then do we come back to the reason to believe?
Well, that's not put an issue. I'm put an issue. I'm just reflecting what the statute says in terms of the safeguard.
Just to deal with that point, we're not looking at that reasonable belief test.
No.
Because, as I understand the legislation, ultimately the revenue can assess if they think that tax has wrongly not been withheld, irrespective of reasonable or otherwise belief. So the dispute we've got is just about beneficially entitled. Can I just clarify?
I think that's right, but this is the safeguard. What is the safeguard? Yeah. And the safeguard does assume the good faith cooperation of the taxpayer.
That doesn't affect the ultimate liability.
No.
Just given.
No, I'm happy with that. But in terms of what safeguard the revenue has, it's not a perfect safeguard because someone who, well, whether in good faith or not, someone who takes a different view of the operation of withholding tax may not operate it when the revenue thinks it should be.
But it's not a safeguard for lots of reasons. The recipient could be totally bona fide and just become insolvent.
Yes.
Or the recipient may be a trader who can properly set off other expenses so that there's no taxable profit. So
both of those things are consistent with the point that the withholding is in respect of someone else's tax liability. It's ultimately in respect of the recipient's tax liability. So of course, if the recipient ends up not having a tax liability, then it's not surprising that there shouldn't be ultimately a payment of tax. And in the right circumstances, if withholding's been operated, the recipient might be able to claim the amount back, for example, of treaty relief.
Yes, but may just be insolvent even if there is a tax.
Well, maybe insolvent, yes, but then that's a risk the revenue always runs in a sense. This is just to stop the position being radically different where the payment is made to a non-resident company. And we say what's happening here is precisely that, in substance, that the payment is being made to a non-resident company just via the device of and those are the findings in effect. So, and that's why we say this is squarely within the clear mischief at which the withholding tax is aimed and outside the clear purpose, we would say, of the carve-out. But I mean, this isn't intended to create a greater tax burden overall than would operate if everyone were paying their tax in the UK.
I suppose it would help me from the course of your submissions, you could try and explain what you see as the scope of your submissions, because in a sense it's easy to see your point about the particular facts of this case, but there are many other facts, and we were taken to lots of cases this morning where there may, for example, be a contractual obligation to pay on and equivalent and so on. What is it? I suppose what I want to understand is what you say demarcates this set of facts from those situations.
I will try to do that, but we say this is an extreme and a clear-cut case, which is on, as it were, the wrong side of the line. The fact that there may be other cases nearer the line, the fact that the line might at times be difficult to discern, that doesn't embarrass us. Or certainly doesn't change the result in this case. We've got here clear findings of fact that this was a device inserted purely to try to escape this obligation with no commercial purpose. We have payments going in and out of Humet on the same day with minimal differences in amount, a fee or a return, or in a few £100, possibly de minimis. We don't have...
You say on the same day. Do we have findings of fact as to when the cash moved?
we don't have findings of fact as to when the cash moved, but we were just shown documents, all of which were executed, well, many of which were executed on the 11th, and there were a couple on the 13th. But
I don't think I saw this morning anything which explained if there was a gap between the receipt by Humet and the payment by Humet to Storier.
well, there probably wasn't an express finding of fact because there was.
Because we don't have the facts. We don't have the material.
We have some facts because they were found by the tribunal in the light of an unsatisfactory evidential position. We have the facts as found, and in effect, this was a conduit arrangement. And my submission is that there's no need to go behind that now to ask whether that was a well-made finding of facts. And it's certainly not something that in my submission, the taxpayer should be able to pray in aid.
Well, I understood there was a finding of fact that there were minimal amounts difference between what Humet received and what Humet paid.
Yes, that's.
But I don't remember seeing something saying that it happened almost instantaneously. And you just said it happened on the same day, and I just wondered where that came
I
from.
may have been misled by the documents we were being shown. We have the findings of fact we have are those at 140 to 142.
It's £500, £799.
We have the earlier ones as to the amount,
Yeah.
which are on 136 and so on and so forth. It is absolutely true. We don't have bank statements for Humet showing funds going in and out. But what we certainly don't have is any suggestion that the money was retained or used by Humet for any other purpose or any length of time whatsoever. And
Sorry, Mr. Vallet, just to be really clear which paragraphs you're referring to,
Sorry.
we've got 140 to 142. I think we were taken to 137 and 138 earlier.
137, 138 are my own friend's submissions setting out what was in the accounts of Humet to give the tribunal then and the court now an idea of the quantum. 140 to 142
Yes.
are findings of fact. We've got and the ultimate conclusion at 140, no business purpose to the involvement of Humet. And the only reason was to ensure that the UK resident company received the interest instead of the Guernsey resident Storier or the relevant Guernsey trust in order to secure a UK tax advantage. So there's no question on those findings of Humet enjoying the payments in any meaningful way. And that's, I hope I'm not reading too much into it. There's no business purpose to the involvement of Humet. I suppose it might be said there's no business purpose, not no business effect, but
Okay. And do you say that applying Ramsey Maxima, the absence of business purpose of Humet is sufficient?
shall I come on to what I
Yeah.
say about, sorry, and also 1413, the fact that Humet was invariably assigned the right to interest only a very short time before the interest was paid. That's also a relevant finding.
Thank you.
I wonder. Sorry,
I think I was
could we just, when you've got a moment, look at page 97 paragraph. It's a very, very long paragraph with numerous subparagraphs. So I will go to page 97 and look at D in the middle of the page. Is that what we're talking about?
That's the general arrangement.
A matter of no more than 1 or 2 days.
Yes.
Is that the period which you were thinking of?
In general, everything happens very quickly. I don't think that is specifically about the payments to Humet. I think that's in general what happened with these payments. I think we might want 1613A on page 100.
There's some paragraphs these, aren't there?
They're very complicated paragraphs. So page 100 of the
Yes.
bundle, page 9 internal.
Yes, so page 100, page 13A,
So this is another one where we're talking about
Storia.
this is Storia, but the overall scheme. So when Storia was in receipt of it,
And there's no suggestion that when Humet was
that it changed. No.
put in the system changed.
So I think it is fair that we haven't got an express finding that it was on the same day by Humet. But we have, I would say, a strong implication from these figures that it was in very short order. We have a clear finding that there was no business purpose. We might.
For what it's worth, and it may make no difference, my reading of 13A is that in the Storia situation, the flow of money seemed to start with Storia making payment for the assignment,
Yes.
then a fresh loan
Yes.
down to the appellant, and then repayment,
Yes.
rather than,
Rather than the other way around.
yeah.
But my argument would be the same either way around.
Yeah.
I mean, the mechanisms of the conduit, in my submission, don't matter. And what we have is a finding that Humet was inserted into an existing arrangement in order to provide an additional argument against the operation of the withholding tax. It was inserted to provide a way to move the interest payment from the payer to Storia in short order. Whether that was done, precisely how that was done, in my submission doesn't matter, and this is without prejudice to cases that might be different, that might be more commercial. We're not talking about a case where Humet is actually making a realistic turn by reference to the amount of money involved. There isn't that. The numbers make that clear, despite our lack of evidence about what Humet was doing. The numbers retained by him are very small indeed. And in light of that, the tribunals reached the conclusions which it reached and which haven't been challenged, that this was a pure tax device. So say it doesn't, I'm not saying, well, a tax device, therefore you lose. What I am saying is, when one sees a pure conduit tax device, well, I will say this, that doesn't answer the statutory description of beneficial entitlement. Not given that one has to take a practical and realistic view of the facts and obviously a purpose of approach to the legislation. As the tribunal says, when enacting that carve-out, can one really imagine that Parliament intended it to be defeated by a tax-driven conduit mechanism? Obviously not. So, I mean, I will attempt to say where the line is, although, because I appreciate that's helpful. But the odd different or difficult case wouldn't detract from the fact that wherever sensibly one draws the line, the beneficial entitlement line, Humet is on the wrong side of it. Is not beneficially entitled in any practical sense. Now I think I've probably covered what I was going to say on my first page. We've got the findings of facts at 136, 141, picked up at 151 in the FTT. I should probably turn up 151. This is just this is the conclusion that the FTT reached in relation to the figures in the accounts. Previously, it was well known for submission that was being recorded at 136, 137, 151 on page 131 of the bundle. It's just explaining why, in effect, the FTT the conclusion it does on the payments. So the tribunal doesn't find that the payments were received as a strict nominee or trustee. That's 153. And did have a beneficial entitlement to the fee element, as it were, to the turn. But of course, the tribunals concluded that as to the bulk, the bits which were just being passed through, the whomit did not have a beneficial entitlement, as that phrase had to be construed in this context to mean something wider than strict beneficial ownership as a land law specialist or chancery practitioner might understand it. We've got a similar point in relation to the interest payments. Sorry, I meant to turn up the Upper Tribunal just very quickly. The Upper Tribunal, tab 5, paragraph 21. This is the Upper Tribunal's summary of what the FTT found, which again I don't think has been criticised as far as it's a finding of fact. You've got 21 finding there was no business purpose for the involvement, and so on and so forth. So that's the basis on which the Upper Tribunal was approaching matters. And while we're in the Upper Tribunal decision, if we go on to paragraph 60, this is on ground 2. This is to do with the Upper Tribunal's approach to the interest, just to show what the Upper Tribunal is doing. So the Upper Tribunal sets out the Hay propositions, or some of them rather. And of course, the FTT agreed with the appellant that the loans fulfilled an important commercial need, etc. I think my own friend read this passage. And then 63, nevertheless, the FTT considered that the loans were intended to form part of the longer-term funding of the appellant and were regarded by each lender as an investment in the appellant. And maybe I just invite your lordships to read paragraph 63 and 64. And that's a 66. That's just the factual context in which the tribunal is going to confirm that these loans are, or sorry, the interest is yearly interest.
So the loans were sort of a chain of loans.
A cycle.
Paid out of.
Yeah. Exactly. That it might not technically have been one loan, in the sense that there was a recycling of funds every year, roughly.
No, just looking at the paragraph, so it wasn't as if these were simply loans that were adjacent to each other and sat adjacently to each other. It was that one of the director explained that the pattern was the repayment of each loan to be funded out of the proceeds of new advance from the same lender.
Yes, sorry, that's what I meant by a cycle. I mean, there was a recycling of the funds roughly annually. It grew over time, but it was meant to be a source of long-term funding. That the whole arrangement was meant to be a source of long-term funding for the appellant. And that is what is said at 63, 64. I'm just emphasising at 65 that the FTT isn't ignoring the, as it were, legal independence of each loan. And that sometimes people say that in the Ramsey context you have to ignore things, and that's not quite right. Normally what you're doing is viewing things as part of a wider whole, or pulling out the tax relevant characteristics of the transaction and not paying attention to tax irrelevant aspects of a transaction, rather than denying the legal reality of what's happened. It's essentially the same point being made here, albeit without an express reference to Ramsey. I'm going to say that in relation to both those findings, in effect, that HUMET was inserted merely to provide a mechanism that was intended to avoid the operation of withholding tax, to transfer funds from one person to another, and that the loans were, the interest, sorry, was paid on long-term borrowing. There's no real, well, there is no dispute, there's no appeal against the findings of facts that would underlie those conclusions. The argument is that in each case, the Upper Tribunal has applied too broad, too practical an approach, and that one has instead, this is what my own friend says, one has instead to apply a more technical, both to beneficially entitled and to yearly interest. So that's what the focus is on. It's not on revisiting the facts, it's on revisiting the legal test and arguing that these are the sorts of provisions that have to be viewed in a technical sense. Now, we say, given that the undoubted starting point these days, and I say these days for the last 40 years, is that one has to take a purposive approach to the legislation and take a realistic view of the facts, that's Ramsey. Given that's the clear starting point, we say one would need the clearest authority to conclude that the court should adopt a strict or even blinkered approach to the provisions in these cases. Now, one authority that might in isolation be taken as justifying that was Lord Hoffman's comments in Westmoreland, but those have to be put in context, and I appreciate that this is a familiar game's the wrong word, a familiar to and fro between taxpayer and HMRC. But whenever one sees that bit of McNiven, one needs to turn up paragraph 38 of the MBF, which is in our bundle, tab 14, and we go straight to page 185.
Sorry, we're in tab 13.
Sorry, the authorities bundle, tab 14, page 185. I imagine this is the sort of passage that my lady had in mind.
I think it may be repeated later in the UBS.
Oh, it comes. Yes. I think this is the first time it was said. Absolutely, this is what I mean about it being a repeated pattern between taxpayer and revenue. So we have at 37. So we're talking about McNiven and Westmoreland. 38. McNiven shows the need to focus carefully on the particular statutory provisions and to identify its requirements. And then we have the qualification of what Lord Hoffman said in McNiven. I don't think I need to read the whole thing, but the thrust of it, I've asked the Lordships to read it. I appreciate your ladyship is very familiar with it. What one is not doing is dividing concepts into commercial or legal and adopting a different approach depending on which of those they are. What one's doing is looking at the purpose of the legislation as a whole and construing the relevant words in that context. And none of the later cases will say anything other than that. All the cases that we need to look at in a bit more detail, the more recent ones, Good Khan, Clipperton, and Booper slightly earlier, but I think we do need to look at Booper in some detail. They all emphasise that the starting point is the particular statutory context in which the words appear. So If we can go to Bupa, tab 17 in the authorities bundle, I appreciate my own friends has gone through much of this, which may let me take things a little bit more quickly, but I think it is important to look at Bupa carefully in light of those submissions. The court has the head note, I think, sorry, page 228 in the authorities bundle.
Yes.
So the issue there, as we've seen, is whether in paragraph 1 on page 230, whether the corporate shareholder which receives the distribution of shares it holds in a subsidiary company is deprived of the beneficial entitlement to that distribution by reason of contractual obligation to pay an equivalent sum to another party. I should have said this. There's no question here that of companies being inserted as conduits or anything of that sort.
But there was at least initially a payment on of 100%
Yes.
of the distribution.
10 days later. And there are findings that in the interim, the company was free to do what it wanted with the money.
So I didn't hear that. The company.
Sorry, there is a payment on pursuant to a contractual obligation of the totality of the receipt. I think we'll come to it. I hope we'll come to it as I go through it. But there was a 10-day lag between the payments in those cases, and the point is made by the court that in the interim, well, first there was no obligation to pay on the precise funds. There was no sort of trust or anything imposed on the funds. It was an obligation. A receipt of X triggered an obligation to pay an amount of X, not necessarily exactly the same money, whatever that means, but an equal amount. In the meantime, the recipient was entitled to use the money as it wished. It could earn interest on it, and it would profit, or it might lose from foreign exchange fluctuations in relation to it. So there was in there a finding of benefit, albeit over a relatively short period, by the intermediate recipient of it. But the first point I was going to emphasise, again, is that this is in the context of different statutory provisions, different act, different context.
But to what, I suppose the question arises, to what extent is it relevantly different? I mean, it's clearly the statutory intention in this particular case that in order to get consortium relief, you not only needed to own shares of the requisite percentage, but have really a real economic entitlement to profits commensurate with that share.
Yep.
So, yes, it's different, but to what extent is that relevantly different?
Well, I mean, we've got the purpose and nature set out at 47 onwards in there. We would say that this isn't a case where it's as clear cut as here, perhaps, that the device of turning off the withholding tax by inserting a wholly commercially irrelevant company, we would say, is clearly outside any possible intention of Parliament in enacting the carve-out. Here, what you have is a qualification of what it means to be a shareholder, in effect. That you have to own the shares, be entitled to the capital and the winding up, and be entitled to the distributions in the meantime, so that people can't, so that people have to have real rights in order to enjoy the relief. I'm accepting that. They don't necessarily have to be wholly commensurate with an ordinary share. It doesn't actually say that. It's got those threefold tests, and we have got a finding here that there was some benefit enjoyed, albeit that after 10 days or within 10 days, an equal and opposite payment was made out again. So I would say that is, in the context of a test that looks at ownership and is held here effectively to focus on what's happening at the moment of the distribution, that is not the same as the wider context that we've got for the withholding tax and the carve-out from withholding, which is looking at whether money is really being paid to a UK resident or is really being paid to someone else through a UK resident, in effect.
Are you drawing a distinction between BUPA looking at legislation which focuses on rights, to profits and winding up, and a situation where you're looking at an individual interest payment? I think. Is that what you're saying?
What I'm saying is that the context of BUPA was looking at ownership. Yes, I mean, I'm saying it was looking at ownership rights.
The rights attaching to the shares in the wider context.
And whether you have the right sort of ownership rights. And that's the context in which the comment about entitlements is made at 51, because you're testing on debt, you're asking whether the recipient would be entitled to the receipt, if any. You don't need there to be a payment of a dividend in order to satisfy the test. You're asking, if there were a distribution, would the holder of the shares be entitled to it? So what it's testing is an ownership structure. Have you got enough of the rights associated with ownership to justify, for the purpose of the tax code, treating the shareholder as truly being an economic owner of the asset? That's the context of BUPA. I'm not sure which of those sitting behind me is happiest. Who's unhappy to confirm that? But yes, it is looking at that structure, and one of the tests is saying, would you be beneficially entitled to the dividend were it paid?
Yes.
As and when it's paid.
Well, that is the way that legislation works.
Yes.
It looks at a notional distribution.
Yeah, and that's not quite the same. I mean, what we're interested in is an actual payment, and we can see that in the legislation. What we're asking is not what would happen if something were paid. We're saying what will happen to this payment that is being made. I mean, without a payment, there's nothing. The withholding doesn't bite on anything. It's asking what happens to the actual payment. I don't say that is radically different, or that one requires one to look at matters dramatically differently. They're both, we would say, asking, does the recipient have the opportunity to enjoy the receipt?
Where does the concept of mere legal shell come from? If I could search my authorities, I'd find it. But
Yes,
Yeah. Is it
Lord
wood preservation?
Lord Donovan, isn't
was
it?
that we were sharing that earlier, were we?
Well,
It may be picked up.
it is picked up in BUPA at 75. I can't remember whether that was. I think it traces through from wood preservation Sainsbury's into BUPA. So it's at 75, which I haven't quite got to 75 yet in what I was going to say. But we have the conclusion in BUPA that BUPA had more than a mere legal shell in relation to the entitlement to dividend. Whereas we would say that, frankly, say for the fee, which is a distraction, Humet does not have more than the bare legal shell.
It was Lord Justice Harman in Wood Preservation on page 44 of the bundle.
I'm grateful, and fortunately that's a cause of the note that I've been handed. So that's where it comes from in general. I think it was must have been the revenue submission in Bupa that was applicable here, and the tribunal concluded that it wasn't. Not least because of these 10 days or so when Bupa could enjoy the money. But sorry, my point about the use of entitlement in paragraph 51 of Bupa, it's the same word, and I'm not going to say it's going to be used radically differently, but I think the leadership and your lordships have the point that in Bupa we're asking what would happen if a distribution were paid. Would you be beneficially entitled to that distribution were it made? Whereas in the context of withholding, one's asking, here is a payment that is being made, is that going to be received by someone beneficially entitled to it? Obviously they're the same words, but the context is different, is slightly different. That was 51, which I think we've gone to. 52, we've got the point about beneficial ownership being, at some points, described as a term of art. But there is a qualification at 53, which should probably be noted, which is that we're dealing, in effect, it's that we're dealing with UK legislation, not English, not only English law, and therefore one would not want to be breaching a conclusion. This is 54, that it only referred to an English law concept. And that's again, that's obviously consistent with what we've seen, and we'll see again, the Court of Appeal doing, or saying about it being a more practical concept than purely, as it were, a chancery concept.
Yeah, that's further explained in
Sorry, yes.
55.
I've elided 2 points actually. One point is that there is an express extension of beneficial ownership, where it to mean indirect economic interest, which is 53, and 54 is the point about the UK and Scotland. So in 55, again, it's the same point, that beneficial ownership and equitable ownership are different. And again, that's 54 and 55 obviously go together. So we're not dealing with a chancery equitable ownership type concept. 56, in the context of group relief, sorry, consortium relief here, the question is whether someone has lost beneficial ownership in light of the transactions that have been undertaken. Here, we're at the other end actually. We're asking whether someone ever acquires beneficial, the benefit has a beneficial entitlement.
So is it your submission that Humet was a mere legal shell, except
In
insofar
effect,
as,
yes.
and that is your submission?
Yes. I could adopt those words. I hadn't done. I was saying conduit, but
No, but I just see from reading this that it, it's been treated as one expression of a test
yes,
in certain statutory contexts.
yes. But I think because I'm thinking of it more in terms of conduit is more feels to me like a slightly better way of describing it because it's passing through who knows. Whereas when one's asking about ownership, one would of course ask the shell analogy is maybe more apposite, but it amounts to the same thing. It's saying, does the person, the putative beneficial owner, beneficial entitlement holder, do they have any
So legal title has no content.
Yeah. Do they have anything beyond the bearer's legal title to it? And my submission is in light of the findings, not here, and that without more than the bare legal title, or the bare legal entitlement, I suppose, one doesn't have a beneficial entitlement. One can't make any practical use of it. Things of that sort. But the reason for emphasising all these maybe individually quite minor differences between the statutory context of BUPA and the statutory context of withholding is precisely that one needs to be careful if lifting comments from one context to another. I mean, at the level of saying bare legal shall is not enough, I'm obviously happy for the lifting to happen, but as soon as we start looking at it in more detail, it is important to have a full grasp of the of some of the subtleties of the reasoning. So we'd say in 56, if it's important to note in BUPA that we're talking about whether someone's lost beneficial ownership, then equally it's important to note in our case that one's asking a closely related but different question, which is whether whomever acquires beneficial ownership. I accept it. In most cases, that is probably too fine a distinction to be terribly useful, but it is one made in the authorities. 57 may explain why the point of 56 is important, that it's possible for beneficial ownership to be in suspense. It's possible for no one to have beneficial ownership, which means that someone has lost it without someone else having acquired it. So it would be possible for a vendor to lose beneficial ownership without the purchaser acquiring it. And if one's asking the question, well, has someone lost it? Then obviously suspension is enough for them to have lost it. If one's asking, has the purchaser acquired it? Then suspension isn't enough for the purchaser to have acquired it. So if one were to find here, although I'm not suggesting this for a second, that no one had a beneficial entitlement to the cash, obviously the appellant would lose, because whomever wouldn't have a beneficial entitlement to the cash. Again, I'm not saying one gets there on this, but it illustrates the importance of the different statutory context. Fourth, beneficial in the context of the group consortium relief provisions means ownership with benefit. So again, we've got an emphasis on the statutory context. I'm not saying that one can disregard this observation simply because of the different statutory context, but that when transferring it to a different statutory context, one needs to bear in mind what one's actually doing. But in terms of what's actually said, that beneficial ownership means ownership with benefit, we would say, by analogy, that for withholding purposes, it means that beneficial entitlement means entitlement with benefit, with the ability, the practical ability to benefit from it. And then we're into at 59. We're into the mere legal shell. From with preservation. And at 60, so mere legal shell, at the bottom of that paragraph by H, the parent company was deprived of all possibility of enjoying the fruits of the shares or disposing of it for its own benefit. That's the mere legal shell. By contrast, so long as an owner has the right, at least to some extent, to deal with the property as its own, the owner has beneficial ownership. And then 61, probably worth noting that ties together concepts of equitable ownership and beneficial ownership. Having noted earlier that they're different, there is obviously a relationship between them. I don't think what's said at 62 onwards in relation to tax planning, construing tax statutes is controversial. 69, just to be clear, and I think I've already said this, I'm not submitting, the Revenue Institute is not submitting, that merely finding a tax avoidance purpose is enough for the revenue to win. But it is obviously relevant because it casts light on the commerciality of what's going on and on the importance of any apparent incidents of ownership. 70 onwards is the application to Bupa's case. If we pick up at 75, we've got the point here, which may be answering your lordship's point about mere legal shell. At 75, this is on page 249. In the contract that Bupa certainly had more than a mere legal shell. And this is the point about the about what it could do with it. All the comments that are being made are against a finding that Bupa had more than a mere legal shell.
There's a statement there, it's irrelevant that Bupa Finance may have been required to utilise any distribution to it. Do they mean in the sense of practically required because it didn't have other resources?
I think so. I'm not actually sure offhand, but
I think that must mean what the from what follows.
I mean, it's the natural reading of yes.
Yeah.
We go to 77. Suspense. So 77, the entitlement wasn't in suspense. 78, it didn't rest with someone else. Particularly at 78, Tawa was the ultimate beneficiary, but didn't have a right. This is what 78 is saying, didn't have a right to call for the distribution as such, merely to be paid an amount equal to the distribution. And then back to the case law, I think we can go to 89 probably. Of course, it might be, it would be, but the court here says it might be a very different analysis if the facts were that Bupa Finance had no access to any benefits of ownership of the cash for the 10 days between receipt of the distribution and the payment of the earn-out consideration. So no right to assign the distribution, no right to interest, or to take the benefit of, be exposed to foreign currency fluctuation. If these were the facts, we'd ignore any feature of a transaction which sought to disguise the absence of the benefit of ownership, to use Justice Harmon's phrase. That's not this case. So, it says Bupa might have been different. I would submit Bupa would have been different if Bupa hadn't had the benefits of ownership identified there. And obviously, my submission is that we're in a world where Humet does not have those benefits of ownership. That is, we say, the only sensible approach to be adopted in light of the FTT's findings of fact, albeit that those were found against an unsatisfactory evidential background. Now, the reason for doing all that is that Bupa certainly is a case where, sort of put short, one could say merely having to pay away a receipt pursuant to a contract isn't enough to deprive you of beneficial ownership. At a very high level, one might think that's what Bupa stood for. I hope what that possibly slightly painful reading shows is that that's reached A, in the particular context of a given statute, and it's not a general proposition, but B, it's against the background where Bupa had more than the mere legal shell, if that's a helpful phrase. It had some of the benefits of ownership. And as 89 in my submission shows, without those benefits of ownership, the conclusion the court says might, I'd say would, have been different. Now, that's Bupa. Next is Khan, unless the court has any questions on Bupa. And the short point on Khan may be one that your lordships already have, which is that it's dealing with different words, different context, and different facts, which meant that there was unsurprisingly a different conclusion. I'm not being facetious about that. It is important that the words it was dealing with simply the word entitled, and it was dealing with it in a specific statutory context. So we I think we've already been to the head note of Khan.
But it wasn't just, I mean, I realise entitled was dealt with as a separate concept, but the language was receiving or entitled to.
Yes. Yes.
We were in that field.
Yes. Paragraph 6 of the judgment on page 335, precisely so. We're dealing with the person receiving or entitled to distribution. And at 7, this is important, I would say, important statutory context. It's a phrase used elsewhere in a TOIA to denote the person who's liable to pay the tax that's chargeable on the income benefit or other payment treated as income, with which the corresponding charging provision is concerned. So, in a sense, we would say it is important that we're the other way round. We're asking whether someone has taken themselves out of the charge by divesting themselves of entitlement, whereas here whom it has to take itself out of charge by establishing entitlement. So those are the words which are different, the statutory context which is different. I think we can go on, particularly in light of the time we've already spent on this, to 49. We haven't turned up UBS. I don't think we need to. It's a more recent Ramsey case. Obviously, I would say it's a helpful and useful judgment summarising the position as the revenue sees it. We have at 49.
We have it in the bundle.
We have it in the bundle if needed, yes. But what I was going to say, I think my own friend read 49 and 50. But we also need to read the second half of 50 over the page. I'm sure your Lordship has this in mind, your Lordships have this in mind. That passage, what Lord Reid has just said, is particularly pertinent when considering the approach to be taken in the present case. It serves as a salutary reminder of the dangers of trying to import interpretations of similar words or phrases used in the context of other statutes, which may have entirely different purposes. It also stresses that not all fiscal legislation is concerned with the overall effect of a series of related transactions, viewed as if they were one composite transaction. Now that's important here because, of course, we'll see, as in Khan, the conclusion is that it is very focused on an individual transaction, which perhaps explains, or does go to explain why why a relatively, or why the conclusion is reached that it's reached, that, and one that, as to entitlement, that might not read across into every other context where entitlement is used. We'll see that, and that's not to cast doubt on the correctness of the decision in Khan. It is just to say that if we try to transpose aspects of Khan, we need to be careful, because we might be transposing them into a different context where fiscal legislation had a different focus. So 51 is actually the taxpayer that's relying on Ramsey here, not the revenue. And 52, this is the point I've just made, in fact. This is a case in which the legal nature of the transaction to which a tax consequence is attached does not emerge from looking at the connected transactions taken as a whole. On the contrary, the statutory provisions require the focus to be on the transaction under which the taxable distribution arose. However, even if one were to take a wider view, it wouldn't help the taxpayer, is what's being said. But it is.
I understand your point, but here again, the focus is on the particular payment of interest in question. So there's not a straightforward demarcation.
Right. But what we say the focus is on, the question is, who is beneficially entitled to this payment, or rather, is whom beneficially entitled to this payment, construing those words in the context of an exception from the withholding tax obligation. That's the full question. And to understand, we say, to understand that, one does need to consider the wider context. Whereas here, the question is, in effect, has the taxpayer done enough to switch off a tax charge based on being the person receiving or entitled to the distribution? So that is a different context. I'm not saying, I don't need to say it's a million miles away, just as it is different. And that's further explained at 57, having rehearsed what the Upper Tribunal said. the Upper Tribunal correctly identified the purpose of 385 and correctly interpreted it as 385 is concerned with the person who actually received the distribution, but different, the person to whom that distribution belongs. In that case, they were one and the same. So it's focusing on those 2 points: who received it, which here is Mr. Khan, and to whom did it belong, Mr. Khan. So that is the importance of the statutory context and purpose of 385, and that's why we end up with those questions being answered as they are. In short, there are questions about benefits and so on. 64 following. I'm picking up the booper points I've already made at 66. Um, 71 to 3 was making the point about a narrow focus again. And concluding at 81, 82. This is Mr. Khan. This is the bit that's sidelined. Mr. Khan derived a real benefit from the payment because it extinguished his corresponding liability to repay the loans. This was not a case in which Mr. Khan's interest in the money could be described as a mere legal shell, with the vendor shareholders having all the rights of beneficial owners over that money. Again, I'm going to say that that's an additional reason, but it's a point of distinction from we say the present case on the basis of the facts found, that these Humet has there's no business purpose to the insertion of Humet in what would otherwise have been a straightforward transfer from the UK resident payers to the offshore recipients. It follows from that Humet got nothing out of it. There's no question of Humet deriving any real benefit from the transaction. The only way one would get to that is by saying, oh, well, we should look at the payment of interest without looking at the circumstances that gave rise to the payment of interest. But that would be, to that extent, I'd say this is a Ramsey point, that one has to see that payment of interest in the context of the acquisition by Humet of the right to interest and the payment on of the interest by Humet. And it's in that context that one sees that the payment to Humet is not a payment to someone that's beneficially entitled to it. It's a payment to someone who is going to pass the payment on to the real intended recipient. And then the conclusion is 83 of Khan. Says there's entitlement in the context of 385 means no more than having the right to tax with income. In this case, the distribution, there's no further implicit requirement of benefit in the sense used in the group or consortium relief cases. So entitlement here is not the same as entitlement in Uber, so on and so forth. And the short reason for that, the word beneficial hasn't been used, it's just the word entitlement. So we say that is Khan, decided on its facts, on different is looking just at entitlement. This does get quicker. Good. Which is beginning at page 383. I think we've covered the facts. This is a case where there was an assignment or an attempted assignment of a right to interest, and the question was the taxpayer nonetheless within the charge of tax, as is set out at page 386, on the basis that he remained the person receiving or entitled to the income. I quite take the point that there are two answers to that in a sense. One is that the implementation mistake, that the assignment was ineffective, but Lady Justice Whipple would have reached the same conclusion in any event on the basis that the taxpayer remains entitled, in the sense that word is used in this legislation, to the income. We've got the legislation at 4, as I've said. We've got Khan summarised at 43. And that's the 43 is a helpful summary of Khan. 49, I think we can skip to 49. Sorry, that's 49. I think I already made Khan concern very different facts. No question of an assignment in Khan, of course. 50, rehearsal of entitlement. Oh, sorry, rehearsal of Ramsey leading to comments about entitlement. '55 is the point we've already seen that's entitled to. The words entitled to do not carry any special meaning. Words of ordinary language. '59 onwards is the point about the assignment. Has there been an alienation? Taking a realistic view of what happened. 62, no. Um, 71 has the point about composite transactions. And one just look at the beginning and end and say that's a composite transaction in short. And then we have the conclusion, 74 to 76. There's a matter of practicality. This is 76. The taxpayer retains an interest and benefit in the maps, which meant he was entitled to the maps. Applying the ordinary meaning of those words being entitled to. So, entitled because retained interest and benefit. And then, as already noted, in fact, there was a technical problem with the assignments. So, maybe the taxpayer's argument would never have got off the ground anyway. But so, what we have in good, again, different statutory context, focus on the individual transaction and the particular question. Conclusion: no entitlement because there was entitlement because there was retained benefit and interest in the thing that we're talking about, as a matter of practicality, as well as a matter of strict legal analysis. Yeah, we say good can't help in a case where can't help the taxpayer establish entitlements in a case where we say on the facts the taxpayer's who met, sorry, not the taxpayer, is a tax inserted conduit, different context. Then we have Clipperton, which explores Khan. Beginning at 33. Sorry, Clipperton is in the bundle, the last authority in the bundle beginning at 409. Appreciate that my Lord Justice Nugee is the author of the main judgment. And
A long time ago.
A long time ago, maybe in judicial terms, but all of what, a week ago in calendar terms. It may have been drafted earlier. So it may be that I don't need to refresh everyone's memory of what was going on in Clipperton. But we're just interested in what it said about Khan. There's a summary of Khan beginning at 33. Given that we've looked at Khan, I don't think we need to go through that. 44. So what happened at Clipperton? The court says, well, if it weren't for Khan, the taxpayer would lose. Does Khan force us to reach a different conclusion? And then at 44, your Lordship has set out what's been said, because Mr. Jones, for the taxpayer, described Khan as a centrepiece and relied on the bit that we've already seen from Lady Justice Andrews. And then 45 is the comments about how much reliance one can put on Khan, and the sort of thing I've already been saying, that one has to see it in context. One has to look at the precise words, one has to look at the precise context. And that is paragraph 45. I don't say there's a read across from the facts of Clipperton to us. We're only interested in Clipperton because, in effect, it adopts the same approach as we would ask this court to adopt in seeing Khan as a decision in a different statutory context on different facts. We don't need to worry about ground 2 at all. So the only bit is Khan. It's all sidelined, but it's really 44 to 43, which is the disposal, the rejection of the argument that Khan forces a different conclusion than the court would have reached absent Khan. And so what we get from it is an endorsement of the point that it's on its very particular statutory wording and so on. So we say there's nothing in any of this to disturb the Upper Tribunal's conclusions in our case on beneficial entitlement. Those are paragraph 24 of the Upper Tribunal's decision, which is at page 61 of the bundle. I suppose, to be fair, it starts page 60, paragraph 23. This is the discussion. the argument is put slightly differently than previously, but we would say that the approach of the tribunal is quite right in light of the authorities that we've just been focusing on, the more recent authorities we've been focusing on. It's right and it's orthodox. 24, the starting point is to construe the words in their statutory context. Well, that's obviously right. 25 and so on, we have a comment effectively about Indo-food. We've got the comment at 26 that one can't say that the general position as a matter of English law displaces the requirement to adopt a purposive approach. 27, we've got back to the statutory context, which takes into account OMAS and the agreed rationale of withholding as capturing or collecting tax on UK source interest paid to non-residents. That's the purpose and the exception that the tribunal sets out.
Well, doesn't quite work like that because this application is for UK resident companies.
Well, fair. We're in the context of payments to companies. So one might add the word company. And then the tribunal says that one should look at the practical reality and concludes that in light of that, the term beneficially entitled does not only exclude situations where the recipient is the fiduciary, but may also, depending on the particular circumstances, exclude situations where the commercial and practical reality of the matter is that the interest, once received by the UK resident company, is then paid on to an entity outside the UK.
Yeah, I'm just picking up a point I was really driving at earlier. I do, frankly, struggle with the closing words in that paragraph because Humet or whoever it is, if they are a UK resident company and are beneficially entitled, and that's indeed the question we're trying to decide, the revenue can in principle look to them,
yes,
as we discussed.
Yes.
So the mere fact that they may be obliged to pay away, and therefore what the Upper Tribunal refer to as the same underlying concern, well, yes, the Upper Tribunal may have in mind the particular facts of this case with whom having been dissolved, but that can't determine the tax treatment.
I'm sorry, I'd read this, maybe I misread it. I'd read this as being, if one has a situation, so it may also, depending on the particular circumstances, exclude situations where the situation is that it's not going to be collectible, if it's been paid on.
Yes, but my point is that
So sometimes it will be. I mean, there will be cases where it's paid to a UK resident and it's paid on legitimately and it's collectible from the UK resident.
But it may or may not be collectible for a whole host of reasons.
True. But what we're looking at is, well, the tribunal I thought was saying here, we're not just taking that narrow view that it means, as it were, strict beneficial entitlement. It's also practical, or lack of practical beneficial entitlement, which means it extends to situations where, as a matter of commercial and practical reality, it's paid on to an entity outside the UK. I accept that it's not in every situation the payment on to an entity outside the UK will render it impossible or even not practicable to collect the tax in the UK. I accept that qualification. But where you've got a situation like this, where the arrangement has been set up precisely in order to defeat the collection mechanism, that seems to me to be the clearest case of a lack of beneficial entitlement. Yeah, so it's not, and that's depending on the particular circumstances, that it's not going to be every case where this application applies. You're looking at the facts. And then we have the comment at 29. Very surprising that you could just insert that device, a device such as HUMET, to escape the application of the provision. 30. We therefore effectively reject the narrow version of beneficially entitled and endorse the FTT's wider version of entitled. So, and we haven't got a challenge. That the challenge, the friend's challenge, is to the legal conclusion as to what's meant by beneficially entitled. If the tribunal, the Upper Tribunal, is correct to adopt a more practical version, there is no challenge to what follows from that, which is that HUMET didn't have that beneficial entitlement. That simply isn't within the appeal. One point also, just to note, by the time we got to the Upper Tribunal, it wasn't a choice between an international fiscal definition and a domestic definition. It was a choice between the practical and commercial approach or the narrow approach. I mean, it may be that the practical and commercial approach is quite like the international fiscal approach, but the Upper Tribunal wasn't reaching its conclusion because it was endorsing the foods of the Court of Appeal as such. And nothing in Kahn or Good or Clipperton requires one to revisit that. Or Bupa comes to that. Indeed, those cases all, well, Bupa clearly adopts a practical approach to what's meant by entitlement. To the extent that Kahn and Good do something else, suggests that a narrower approach might be adopted. You say that that is because they're dealing with different provisions. And in any event, in each of those cases, the tribunal also goes on to say, well, the taxpayers had a benefit from the relevant payment. They had, in effect, they had a beneficial entitlement anyway. What we haven't got, we say, is any support for the proposition that in any of those cases, that beneficially entitled should apply to someone who has no practical enjoyment of their receipt. I focused on the more recent authorities. There's a little bit more in the skeleton, but I don't think I need to go through that. What I say in the skeleton on ground 2 is really very short, and I don't think I need to expand it. The point there is that the authorities, effectively, and in particular Lehman, say one needs to ask whether, again, it's a matter of business-like approach, we're talking about interest on a short loan or a longer loan. Well, sorry, a short finance or longer finance. The tribunal, having found that these individual loans were all part of a longer term financing arrangement, it naturally concluded that the interest was yearly. That's unimpeachable. The suggestion that one should ignore the fact that the funding is part of it takes place in that wider context, not merely sequential but actually recycled, is at odds with any is at odds, we would say, with the cases that lead to the recent decision in Lehman, but which are themselves long-standing authority, and it certainly is at odds with any purposive approach to the legislation. This is that's the short version of the argument on yearly interest, which is set out really by the Upper Tribunal and which we endorse in the skeleton.
Do you accept that if you simply had one transaction of less than a year, that would be short interest?
Not necessarily.
Not necessarily. So
I mean,
what's the determine?
Well,
What is the determining criterion?
it is to do with the intention at the time that the loan is advanced. So a mere accident that brought it to within.
Okay. But let's say it's a 360-day loan, full stop.
360 days.
I'd understood that would be accepted as short interest.
Yeah, if there's no, without the context,
With no intention to.
with no, yeah, that's well, with no intention and without any other context, because in that, if that were a single loan in isolation that didn't form part of a wider, longer financing arrangement, let's say, to make it absolutely clear, one that wasn't in any way structural. So it's simply someone saying to the bank, "Can I borrow £1 million for 360 days?" To an offshore lender, I suppose. Can I borrow £360 for, sorry, £1 million for 360 days? I will pay you interest on that. Then that would be short interest. That would not be yearly interest. That would be short interest. I think that's where the line. Yes, with no intention to go beyond that. Absolutely. So it's the true intention.
Well, the reality, I presume, is that as soon as you saw a 360-day loan, you think, what's going on here?
Well, you might
and
be
then,
put on notice.
so you put you on inquiry, and then you might be very well satisfied that it was entirely appropriate as a
Yes.
one-off, and that's that.
Well, let's add that there's a commercial reason to limit it to 360 days, just to avoid any suspicions. Yes. So there will be, in a sense, the year is the cut-off, hence the use of the word yearly interest, but only once one takes a proper view of the full context of the loan, or in this case, loans and wider funding arrangements. And that's what the tribunal did. I would say that is the proper approach. And the alternative that suggests that one could take a funding arrangement that would otherwise give rise to yearly interest and avoid the application of that merely by chopping it up into presumably 364-day chunks, that we say is completely unrealistic and wouldn't reflect any sensible purpose behind the legislation, and doesn't reflect the authority. I haven't dealt with that in detail because we're really just endorsing what the Upper Tribunal said.
Anything else, Christopher?
Sorry, I'm being given some figures about the extent of the fees if they're of interest, but it's.
Well, if they're in the evidence or can be extracted from the evidence.
That's why the Prince said this was only a decision in principle. So there is an element of, I think it's roughly 10,000 of fee in relation to all. Well, we say a fee in relation to all the transactions. It's that level.
In relation to all the transactions.
All the HUMET transactions, yes.
Which you were going to tell us at some point amounted to roughly what? Because there was a distinction between the HUMET and the previous lot.
I mean, it's hundreds of thousands. I can't remember the exact figure.
We did a percentage, didn't we? But what would you like to know?
Well, we've got this figure for 40%.
Yes.
In relation to ground 2.
Yes.
Do we have any sense for what that sort of? I know it's more complicated for ground 1 because it only affects some of the later loans.
If it helped, we could probably send that in tomorrow, if that would help.
Well, it probably doesn't make that much difference, but I think you've taken us to all the findings of fact. that we
Yes.
have.
Yes, the total borrowing runs into the millions. It's only
Yes,
a
but
question.
Humet just gets a right to
Who it just well,
oh,
it gets a right of some sort to interest, but whether it's a beneficial entitlement is the question. And I think that Humet figure is probably higher than the 40%, isn't it?
I really don't know. I'm
Okay.
sorry. I think you're right. I don't
But
know.
it will be. Maybe we should try and agree it rather than me speculating about it.
Right.
well, we've got the amounts of interest paid to Humet at paragraph 138 in 2 financial years. So those are the relevant financial years, 2014 and 2015. And more years.
Yeah, there were more years than that.
Okay, so that's not all years.
No, I
So
think
that takes you to about, even those take you to about 4.5 million for those 2 years.
Is that, and some in relation to other years as to which the 10,000 of fees applied.
the fee, that's the total amount paid to Humet across all years, isn't it? Is that in all the years? Okay, so we say it's roughly, looks like that was 10 million roughly total interest with a turn, if that's a neutral phrase for Humet, of 10,000. It's that sort of level anyway.
So you think it's, you say it's approaching 10 million to Humet,
Yes.
and that's obviously not the whole of this,
That's the interest payments.
the original appeals.
That's not the whole of the original appeal, no. No, the numbers are quite big.
Well, the total interest paid is at paragraph 2 of the FTT, there's a table.
Yes,
Looks about 14 million to me.
yes, and it's the later years which are Humet years.
Certainly the last 2 years, those figures.
I think it's the last 4 years which are Humet years. Yeah. So that would be about right. It's roughly 14 million in
That's
all,
over 10 million, yes.
and over 10 million to Humet, yes. Yes, it's sometimes a good idea to go back to the decision.
Thank you.
Yeah, so we've got 2.8 million tax, and roughly 60% of that will be, yes, 10 over 14.
Yes.
Subject to more and more accurate arithmetic. Is there anything else?
No, thank you very much.
No.
No, thank you both. Yes, Mr. Wade.
Thank you. That was a very brief points to make.
Yes.
If I could just take you to one point that I ought to bring to your attention, which is in relation to the meaning of source in this circumstance, and the requirement to withhold tax. It is in the Lehman case, which is in the authorities bundle at tab 20, and the page I would like you to look at is page 380. That's my writing. 330. Sorry, my writing. 330. And it's paragraph 57. Because the point is this, and I'm not making a big point, it's just so that this is not overlooked. We are talking about the tax that Humet might pay, and in a normal situation is the withholding tax on account of the recipient's tax liability in practical terms. And in the Lehman case, what Lord Briggs said was that there is no source for the purposes of the Section 874 test. It just is an obligation on the payer to account for withholding tax at source if the legislation applies. So I'm not making any point. It's just that I think that's rather, to my way of thinking, rather an odd outcome. But it's there, and it's the Supreme Court. So we're not to not overlook it. In other words, I make this point because in my submissions in the First Tier Tribunal, I made the point that I felt that in trying to understand 874, you were saying 874 is accepting that the overseas recipient might otherwise not pay tax, and it was their source. This is just saying there's no source for 874 purposes. I'm not making any point. It's just, I think it's a point that perhaps is relevant in any judgment that's forthcoming.
Thank you.
The only small points are just, we're talking about, we use the word conduit, my learned friend used the word conduit, that Humet was a conduit. I just make the point that in the Indo-Food case at Chancery Division, which of course was overturned, but it was overturned because the English law didn't apply. In the Chancery Division, the Netherlands company that was put in place was nothing more than a conduit, and yet it was held that that had beneficial entitlement in that situation. So there are circumstances where a conduit can still have beneficial ownership. And if we're saying that the lack of business purpose is going to mean there's no business and no beneficial entitlement, of course the case of Westmoreland, Macniven and Sainsbury's, neither of those had a business purpose. The payments of money from the pension fund to Westmoreland and back had no business purpose. They were purely to make sure losses were available. And in Sainsbury's, the creation of the option rights had no business, or the creation of the special 5% share to allow the group relief provisions to apply had no business purpose. So those are the only points I want to make by way of reply. And if I've got any questions,
No, thank you very much. Thank you very much, Mr. Way. And thank you for not using your reply to begin on your submissions all over again, which so often sees. All right. Well, thank you individually and also those who support you for the efficient way in which the case has been prepared and very effective way in which it's been argued. You've given us something to think about, and we'll do that and let you have our judgments in due course. They'll be sent to you for proofing and correction of inaccuracies. And we'd be grateful if you could provide a draft order reflecting our conclusions, and in the meantime respect the confidentiality of the draft, please. If there's anything you can't agree about, we'll decide it on paper, and we won't trouble you to come back for any further in-person hearing. Thank you all very much.